All right. Is there anyone here who's ready and your client is not in custody because they're bringing inmates up? Yes, who do you have? Can I see the file on Ramirez? Is it up here? Okay. All right, Aaron Ramirez. All right. So on this case, where are we on discovery?
My knowledge discovery was completely turned over by the state. We were brokered a plea offer. Your
Mhm.
Honor. My client needs time to consider that plea offer. Perhaps the sources that judge.
Okay.
I think I already have to be back on the 16th, Your Honor, January.
All right.
I may come back at that date. Inform the court whether my client's going to accept the plea offer.
All right. So we'll come back on January 16th, and that will be your plea deadline date. On that date, you need to let the court know whether or not you reached an agreement with the state. If you have not, your next setting after that will be a jury trial date. And if you all could do an acknowledgement of discovery, please. All right. Thank you. Thank you for dressing appropriately for court. Okay. All right. Thank you.
Thank you, Your Honor.
Norma, the plea deadline on that case is January 16th. You're welcome. Hi, is he on bond? Okay, just give me 1 second. And what's your client's full name? Okay. You're welcome. You're welcome. Are y'all ready on Mr. Cox? Okay. Sure. And your client on bond or in custody? All right, as soon as they bring him out, we'll take it up. Anyone else has someone who is not in custody? All right, which case is this? Can I see the file on Joe Ramos? Good afternoon. All right. Joe Ramos. Why does it say Jonathan Mitchell hired on it, on the docket? Okay. All right, do you have an attorney? All right. Okay, just have a seat. We're gonna make sure that you have an attorney. And do you have that file?
Bring it over now.
Okay. All right, Mr. Ramos, if you'll come forward, please. All right, Ms. Enriquez is going to be representing you on this case. All right, and Ms. Enriquez, if you'll confer with the state, and then you can come back and get a reset date. All right, thank you. Thank you. All right, who's here on Leopold Ruiz? Are you ready to proceed? Court is calling 2024 CR 0087888, State of Texas versus Leopold Ruiz. Can I have parties announced for the record for the state? Defense? And are you Mr. Ruiz? All right, you entered a plea of guilty on October 15th. According to your plea bargain agreement, punishment is to be assessed at 10 years in the prison. State recommends community supervision. The causes being taken in consideration are 2024 CR 008803 and 2024 CR 00851. And there's a restitution amount of $42,070 to Louis Vuitton. All right, have both parties had a chance to review the PSI report?
Yes, sir. Yes, sir.
Any objections to the PSI report?
No.
And let me see here. Does any party have any witnesses? All right. So, and there's an agreement that the restitution amount owed is $42,000? Is he ever going to be able to pay this? I mean, let's be honest. Does he have a job where he can pay back $42,000? All right, so does he have employment where he can pay back $42,000?
At the moment, I think the larger concern on, at least on our end, or what we were hoping for, was it does seem, as the person reviewed from the top evaluation, that the chronic drug use has been for 10 years. Speaking with the family and speaking with him, it does seem that substance abuse could contribute to this offense, and we're asking the court to give him some treatment for that.
All right, but is he ever going to be able to pay this $42,000? Here's the thing, Louis Vuitton wants their $42,000 back. That's what they want back. And I'm assuming this is not directly going to Louis Vuitton. Was this at the mall at San Pedro or somewhere else?
My understanding is that
All right, so it's at Saks Fifth Avenue. So, okay. All right, so then we're just spinning our wheels if he's never going to be able to pay this back. And when I say pay this back, I don't mean, oh, 2 years elapsed and he pays $300. So I will accept this plea bargain agreement if he pays a majority of, or at least half of the restitution up front. Because otherwise, what's going to end up happening, he's going to be on probation for 10 years and Louis Vuitton may have received $500 back. So he needs to pay some of a good portion of the restitution. Okay. Oh, I'm not going to accept this plea bargain agreement. Because I mean, he's never going to be able to pay the $42,000 unless we're just putting him on probation, have him take some theft courses and say, please don't steal again. And, you know, so sorry for Louis Vuitton, you're not getting your restitution. Yes. All right. Unless y'all are going to come up with some funds for Louis Vuitton. All right. So, Ms. Ferguson, put this on the jury docket. for January 7th. All right, we'll see you back on the 7th for jury trial. Thank you. Sure. Ready on your case? Who's your client?
Guadalupe Roque.
Let me see if I have that up here. All right, I do not have that up here. If you could pull Roque, please. Oh, I'm sorry, just one moment. Yes. Yes. Sure. All right, thank you. No, thank you. Yes, you're welcome. Guadalupe Roque? Yes.
I wrote taking into consideration two cases. We will be rejecting those cases, but it's gonna be for extreme.
All right.
And what about the no conflict?
is, so as part of the plea, we the state were asking for no contact order, but it sounds like the PSI report was asking for harmful injuries.
Right.
And plea defenses as well. I'm gonna have to leave it on that one because I can't agree with the whole.
All right, so the causes, where it says causes taken into consideration, that should be causes rejected. All right, court is calling 2024 CR 007560, State of Texas versus Guadalupe Timothy Roque. Could I have parties announced for the record? State, defense,
Richard Garcia for the defense, ready, Your Honor.
and are you Mr. Roque? All right, you entered a plea bargain agreement where punishment is to be assessed at 5 years. The state is recommending community supervision. The cases being rejected are AL 2147977 and 2178735. There's an affirmative finding of family violence, $200 fine, and there's no application for deferred adjudication. Have both parties had a chance to review the PSI report and the TAP evaluation? State?
Yes.
Defense?
Yes, Your Honor.
Any objections?
Well, no objections.
All right. Any witnesses? State? Defense?
No witnesses, Judge.
All right. Anything you wish to say on behalf of your client?
Well, Your Honor, after speaking to Mr. Roque and reading the PSI, it sounds like his father is ill and needs Guadalupe's help. And if you do send him to safety or SATIV, he'll be away for at least 6 months. And it sounds like the father is seriously ill right now and needs his help. They lost their mother a couple of years ago. And then the PSI indicates that that they spoke with Mr. Roque Jr., the father, and he wants a no harmful or injurious contact order, and he wants his son to come home. And so, and Guadalupe here doesn't really want to go to SATIV or SafeP, but would be willing to do outpatient. I don't know. You want to speak?
You want to raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth so help you God? All right, you can lower your hand, state your name for the record.
Okay.
All right, what do you wish to say?
My dad is like close to death, and I usually talk to him, and he's needing some help.
Let me ask you this. You're here for hitting your dad? All right, and according to this, it says, I asked the victim what had occurred, and he explained that you and he were arguing over tires inside the garage, and that you threw a large tire and hit the
No,
victim with it.
That was
The
him.
victim confronted the suspect for nearly hitting him, then proceeded to go inside his truck to retrieve his cell phone to call 911. So,
My dad threw the tire.
Okay. well, let me explain to you where we are today. Where we are today is, one, I'm not going to lift the no contact order. So if I will allow him to speak to him on the telephone if he wants to speak to him on the phone, but in-person contact, that's not going to be allowed. They think you need inpatient treatment according to the TAP evaluation. So the recommendation is for safety, followed by aftercare. So that's what's going to happen. Now, the other option, if you want to do something else where I send you to prison for 5 years, I can send you to prison for 5 years.
It's the aftercare treatment though. Is it like a
3 months.
yeah?
So 6 months, 3 months.
Yes.
There's another one though called treatment. What's it called? Recovery, lifetime recovery.
Yes, but you're going to safety.
Can I go to lifetime recovery?
You're going to safety. Okay.
Change it.
All right. And I see, and I want you to know, I read the TAP evaluation and I see where your father wants you out because your father wants to help you find a job and help you find a place to live. You're an adult. That's what you're supposed to be doing yourself, not your parents. You understand? All right. Anything else from either side? Any questions?
or actually, that's a good solution, giving BSI to play the state to the officer that he does have liver cancer.
Mhm.
And I think it's a good balance for that. I don't have to communicate over the phone.
All right, the court will find you guilty, sentence you to $200 fine. That will be probated. The state will reject AL 214-7977 and AL 217-8735. There's to be proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. There's an affirmative finding of family violence. There's to be no in-person contact with Guadalupe Roque, the father. Regular reporting by Zoom or in person. Regular random UAs. Safety followed by aftercare. And probation, you can do a referral to felony drug court. And all of this is to take place in custody. If he's not accepted into felony drug court, then he's to be transferred to safety. Anger management. No unsupervised contact with minors. 120 sober meetings in 120 days. Field visits 1 time per month for 8 months. 100 hours of community service restitution. Probation, is there anything else? Is there anything else you need from the court in order to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Right to Appeal? With your attorney, did you understand it and sign it? Yes. The term? Thank you. All right, the court is going to sentence you to 5 years in the prison, suspended and probated for 6 years. All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
It's 5 years.
Yes. Well, you're going to be on probation for 6 years. If you are unsuccessful or a motion to revoke is filed against you, then you could potentially be going to prison for 5 years. Do you understand? All right, good luck to you.
But you could also early. I put it to be about.
Thank you.
Thank you. Yes.
Yes. Okay. Are you all ready on Michael Cox?
Yes, Your Honor.
Yes. So where are we?
On the two cases, we've agreed to plead true and continue the MTR cases. On the third case, we are agreeing to a reset, so we come to a resolution on the new case. That this would be the first setting for.
Okay. And did you fill out a trial court certification?
Oh, Your Honor, I need to do that.
All right, thank you. But on Michael Cox, the cases that are the new case, recall that back for January 13th for disposition. All right, and let me ask you all, the new case, the new theft case,
Yes, Your Honor.
were you all aware about that new theft case when he was placed on probation for these cases, or those are just new charges?
It's a new charge with a completely different person. They're all business deals gone south, Your Honor, and it was not related to the same complaining witnesses. We were not aware. We didn't know that it was pending. It got filed after the other case.
State?
Enter this plea, Your Honor, couldn't have been aware of it.
All right, so this is the court's question. He's on probation for 2 thefts. What I'm trying to figure out is whether or not after he was placed on probation, he picked up this new charge. That's what I want to know.
So, Your Honor, didn't represent him on his original plea. I only represented him on MTR for these 2 counts. And then I represent him on this new charge. I don't know anything about that.
So does anybody want to look to see what the offense dates are and whether or not he just picked up new charges? That's what I need to know, because he's on probation for 2 thefts and he has a new theft case.
Yes, Your Honor.
So once y'all have discussed that, let me know.
My
You can
understanding.
step back. Thank you. John Pena? You don't have any motions or anything, do you? To be heard?
I don't.
All right, just give us a moment. The jury's outside, let me clear the box and then. Joe Ramos, are you all ready?
I think she's still conferring outside with him, Your Honor.
Okay, thank you. Eduardo Reyes? All right, and your client has been dressed?
Yes, Judge.
Okay.
And just for the record, I spoke to him. He doesn't want me to represent him. There's also what he was found incompetent at once, and then he went to the process of restoration. The process of restoration, he did not participate in it. So they found him that he regained competency after that based
Do
on
you
other
think he's
reports.
competent?
I can say that. So I filed a motion for that earlier today, but
So you don't think he's competent?
I can't tell because he doesn't talk to me.
I have my reasons. I have medical reports. And I can take medication and but right now I choose not to because I want to work. You know what I'm saying? I'm trying to get probation. I've been incarcerated this whole time, trying to stay positive.
All right, so let me explain something to you.
I just need
All right, this is what I need you to do. I need you to listen to me clearly. Are you ready to listen?
I need a new attorney,
Are you ready to listen?
please. That's all I'm
Are you ready to listen?
asking. Of course.
All right, so listen to me clearly. When you have a criminal case, if someone thinks that you're incompetent, which means you do not understand what the nature of your charges or the consequences of your charges, what
Enjoy.
ends up happening is they file a motion asking for a doctor to evaluate you. The reason why that is done is because he's not a medical doctor, I'm not a medical doctor. So a doctor will come and interview you. If a doctor determines that you are not competent, which means you don't understand the consequences of entering a plea or the consequences of your charges, they will either try to restore you and release you from custody, or they will send you to the state hospital. If the charge that you are facing is considered a violent offense, then they will send you to the state hospital. Your attorney cannot do anything until competency is restored. Once competency is restored, what that means is you go see Judge Andrew Carruthers because he's the criminal law magistrate. They will have a hearing saying that your competency is restored. Then what will end up happening is you will be brought back to this court. And what I can tell you is you should be speaking to your attorney because your attorney is telling me, here's the thing, your attorney,
I'm not gonna
your
sign.
attorney, here's the thing.
There's no
Wait,
witness.
here's the thing.
evidence.
Quiet. Whether you want to sign for it or not does not matter. And when I say it does not matter, it's because if you don't want to sign for it, then you'll get a jury trial. But if you don't speak to your attorney, he's saying that he thinks you may be incompetent. And you know what that means? Once an attorney tells a judge that they believe their client is
Later on,
incompetent,
all that.
the whole process starts over again. So that means that you will be sent back to have another hearing with another doctor. And then if that doctor thinks you are incompetent, you're going to go back to the state hospital and you're going to sit at the state hospital until they restore your competency. And then it's going to go back to Judge Carruthers. And then if Judge Carruthers says your competency is restored, then you'll come back to this court. And then if your attorney tells me, well, I think he's incompetent because he's not talking to me, then you know what will end up happening? You'll go right back. So talk to your attorney. If you don't want to accept what the state is offering, you don't have to.
You
Okay.
already know that.
All
I
right, do
took
you
my
believe
test.
he's incompetent?
I'm not an expert judge,
confused
but
on this.
I have reason to believe that he has been diagnosed with mental illnesses in the past, and he is not on his medication for sure. So that's all I have from the reports I read. I just don't know, Judge.
All right, do you want to speak with your attorney so he can let the court know whether or not he thinks you should see another doctor? Or if you don't want to speak to him, I'm just going to go by what he says. When he says you need to speak to another
I
doctor.
already went on 24.
Do you wish to speak to your attorney?
No, I don't have an attorney.
All right, so you think he's incompetent?
Yes, Judge, I just.
All right, Norma, have him evaluated for competency.
Thank you, Judge. Maybe excuse.
Yes, thank you. And Norma, see if they can expedite that. Are y'all, anybody who's in the box is ready? Who's the person in the blue shirt?
think it's Megan's playing.
Yes. And are you ready on your case, Mr. Hagee?
I am.
So do y'all have answers for the court?
I do, Your Honor. So it looks like this took place somewhere in the summer of 2023.
Mhm.
There were many communications between my client and this particular CW about repaying them out. There were attempts made
Mhm.
to repay, and we have all of the restitution to pay up front.
Mhm.
The state in this particular case has delayed us moving forward with that. I apologize. Because they want to speak to the CW before accepting the restitution on her behalf.
Mhm.
So that's where we are with this new case. It is a
Alright.
case that we've been trying to repay the debt for months now.
Are you all able to get in touch with the complaining witness today?
Tried calling her, Your Honor, but no, haven't had a call back.
All right, if y'all can have your advocate call them now, email, text message. All right, just have a seat.
Thank you.
We're gonna take care of this today. All right, and are you all ready on your motions? Yes.
We did confer, and there were some that we agreed on, there were some that we did not agree.
Okay. Just one moment, let me log into Odyssey.
Go ahead. Scoot up.
And I'm assuming jurors are not in the hallway yet?
Yes, 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 in the hall.
Oh, well, why didn't anybody hand me? It's Monday. Yeah, I just been like, okay, I guess the jurors are not here yet. Thank you. I'm gonna see, just 1 second. All right. All right, motion for, the court is gonna go on the record in 2024 CR 0176 State versus Arturo Villanueva. Counsel, you on this side? Could I have parties announced for the record for the state? Defense?
Your Honor, good morning, Daniel Vela on behalf of Mr. Villanueva.
And are you Mr. Villanueva? All right, with defense, you have motions. Motion for discovery or exculpatory and mitigating evidence. Have you all agreed on that? State, you have to turn it over. Do you have any?
Not as far as I'm aware.
Okay, so that would be granted. Motion in limine. I don't know what this case is about, so if you all can approach before you bring up any of this evidence, and you have it for 609 and 3707, counsel.
Yes, Your Honor.
Is there anything specific?
Well, no, not to my knowledge as far as my client,
Okay,
but I did want some, well, that's another motion. There's.
okay. Motion for a witness list. State, did you turn over a witness list?
No, Your Honor.
All right, they need a witness list. Why are we just having motions on witness lists?
You'll need to ask defense counsel.
All right, why are we just having motions for witness lists?
I filed that motion,
November 25th.
correct, but I previously, I could have, well, I filed that motion on the 20, I conferred on the last setting, Your Honor, regarding that, and I haven't received one.
All right,
I'm entitled to that 7 days prior to trial.
well, I mean, these are motions that I've just been tendered. So if y'all want to go back, see if you can get him a witness list, State.
My argument would be, even if I get it today, it's untimely.
Your Honor, my argument is
wants the time of witnesses, then he needs to bring the motions requesting such to the court in a timely fashion, which he has not done.
I believe I did, Your Honor. I filed it well before 7 days prior to trial.
All right, so here's the thing. There's not going to be any surprises. So one, need to turn over, state the court realizes that you just received this motion for a witness list. So if you could get a witness list to the defense, and it appears that the defense is saying they're not going to be ready because they would just be receiving a witness list that they just requested. Okay. So motion to suppress, that can be carried with trial. Motion for discovery of the arrest and conviction records of the state's witnesses. Legally, that's to be given to you or for your view prior to the witness testifying. Have you had a chance to view any NCIC, TCIC as it relates to any witnesses?
No, Your Honor.
All right. Motion to suppress photographic identification. That will be carried with trial. Motion to quash an exception to substance of indictment. With regard to this motion, there are blank spaces in this motion.
Right, Your Honor.
So
Uh,
I can't entertain a motion that has blank spaces. It says Mr. Villanueva was charged by indictment on blank.
I understand. What was that motion, Your particular, Your Honor? The
Motion to quash an exception to substance of indictment. So your motion has blank spaces in it.
Right.
And number 4, it says the accused rights under the 5th, 6th, and 14th Amendments to be fairly informed of the charges against which he was required to defend was denied by the failure of the indictment to allege an essential element of the offense, namely, and that's a blank space. So what are you alleging that
Well,
they failed to do?
we can waive that. We can waive that.
So you're waiving the motion to quash?
Correct.
All right, the motion to quash and exceptions to substance of indictment is waived.
Your Honor,
Yes.
I know the court said that the motion to suppress was going to be carried with the trial.
Mhm.
What I want to, in particular, what I would like to get at is when they bring the investigating officer, their chief investigating officer, I'd like to go into substantial questioning about the arrest, the affidavit, arrest warrant affidavit, and that in particular is what I'm trying to suppress. So I would ask the court that when it gets to that point, that I get a separate hearing for that issue.
Yes. All right, and then motion to compel election between charging paragraphs.
Your Honor, this particular charge, there are 2 paragraphs, account A and account 1 and account 2. The count 1 is the way it's been alleged is an aggravated assault with a deadly weapon. Count 2 is a failure to stop and render aid. And our allegation, what we're alleging in there, what we're asking the court to do is make the state prove one or the other. They're two different elements and 2 different culpability requirements alleged. in
All
each
right,
one.
it sounds as though you're requesting a severance of the counts.
Correct.
So you need to file a motion then asking that the counts be severed. And then the court, that would be the proper motion, then the court would hear that.
I would ask for leave of court to file that motion, Your Honor.
State, he's asking for leave of court to file a motion to sever the counts. He is asking that there be 2 trials, one for count 1, one for count 2. He's asking for a severance. And of course, you'll bring the court case law on why you would be entitled to a severance at this late date. And the court would hear it. So I'm assuming your motion for speedy trial, you're withdrawing that because you want a severance of the 2 counts. No motion has been filed by you for severance of the 2 counts, and you're asking leave of court to do so. Is that correct?
At this point, Your Honor, yes, I would like, it was a recent, the indictment is a fairly recent indictment as to one of the counts. In particular, count 1.
So you're waiving your right to speedy trial?
No, Your Honor.
then you wish to go to trial today.
I can confer with my client regarding that issue, Your
All
Honor.
right, because the leave of court that you're asking for me to allow you the date of trial to sever the counts, that doesn't give the state proper notice. Am I wrong in that?
Well, I would agree with the court on that, but going back to the witness list motion, I would assume that the state has to ask for leave of court to file their witness list.
Well,
which
there's
they
an
have not
issue.
asked for.
There's an issue with regards to the witness list and it not being requested and whether or not you have notice of the state's witnesses through the discovery. For example, if the state were to call a witness that's not within your discovery packet, then of course I would not allow the state to call that witness. But for example, you're aware of the detective, that they'll probably be calling the detective, because you're telling me that you want to do a motion to suppress and it's related to the person who investigated.
I'm assuming that that would be one of their witnesses, Your Honor.
All
That's
right,
correct.
so if you
But-
want to discuss with your client the right to waive well, you're withdrawing your speedy trial motion, the court will hear it, but otherwise, then I don't see how it would be fair just for me to allow you to have leave of court to file a severance to the 2 counts when that has never been filed before.
I understand, Your Honor. It would,
So if you
I
want to
can
just,
go into the procedural history of why, Your Honor,
Okay.
but let me confer with, if the court can allow me to confer with him real
Yes.
briefly regarding the issues.
all right, you're welcome. Yes. Joe Ramos? All right. So you had chance to meet with your client?
Yes, Your Honor. I had a chance to meet or to confer briefly with the prosecutor and just to get a little bit of background with him. And I'll tell you just in the little bit I know, we'll probably have to file motions for competency and some other evaluations.
All right, sure. So what we'll do, my understanding is that this case has been indicted. I don't have the indictment number, but
Oh,
thank
I
you.
have it.
All right. So what we'll do is we'll reset it and we'll reset it for discovering if there's a motion you feel as though you need to file, then you can file that motion.
I will, Your Honor.
So make sure that you stay in contact with your attorney. And then what we'll do is we'll recall this back and we're going to recall it back for the new year. I think that'll give everyone a chance to catch up on things and
Sure.
catch up on discovery. So, Ms. Ferguson, can you put this for January 27th?
Yes, ma'am.
All right, we'll come back on January 27th. Do you have any questions, Mr. Ramos? All right, thank you for dressing appropriately for court.
And Judge, just to let you know, we are going to be asking the MAC for some resources for him. There's some things that they can help us with, hopefully, with regard to him.
All right,
So-
thank you.
Thank you, Your Honor.
You're welcome.
Thank you, Norma.
All right, Deputy Mejia, it looks like we're proceeding on Mr. Pena. Okay. You're welcome. Mr. Villanueva? Defense?
Yes, sir.
Yes. So are you withdrawing your speedy trial?
I believe, yes, I've discussed.
All right, we're gonna go back on the record. And 2024 CR 0176. All right. And on that case, you're withdrawing your motion for speedy trial?
Yes, Your Honor.
All right, on this case, y'all are gonna come back on Thursday. And the court is gonna hear your motions and state you'll need to get a witness list to the defense.
And a 404B motion, Your Honor, which I think I'm entitled to.
Well, I'm not over the 404B mode. You just need to file the 404B
I have.
and state. You need to make sure that's turned over. If it's not, then I'll address that issue at trial. And it probably won't come in if you're not receiving notice of that. So Norma, on Mr. Ortiro, Villanueva, we're coming back on Thursday.
Thank you, Your Honor.
Thank you. And Norma, even though we've sent him back, if you'll make sure that it's put in the notes that an interpreter was here for Edgar Aguilar.
Already needed?
No, we sent him back. We're gonna have to bring him back on Thursday.
Thank you. Thank you.
You're welcome. All right, and then on Pena, what, could somebody find Raymond Martinez, Norma?
Victoria was just here.
So that we can have the jury come in on this? And what is happening with Mr. Cox?
Don't know if the state's gonna be able to get.
Were you able to get a hold of the witness?
Yeah, Your Honor.
All right, y'all coming back tomorrow. Norma, recall Mr. Cox for tomorrow.
Your Honor,
Yes,
can we be on the afternoon docket? I do have a setting.
sure. Yes, we'll put you at 1:30.
Thank you, Your Honor.
How much time are you guys asking for Guardia? All right, and on Mr. Pena, it's the theft, 2,500 to 30,000? And has he filed his election if he were found guilty? And the election is going to, all right, to the court? Okay. If the election is going to the court, do you all wish to do a bench trial or no? All right, and Mr. Pena?
Ma'am.
Let me tell you what I tell people about bench trials.
Ma'am.
I've had people to come before me on bench trials. They've been found guilty because the state has proven this case. I've had people come to me on bench trial. They've been found not guilty because the state hasn't proven their case. For the court, if it's a murder case and you come to me for a bench trial, if the state doesn't prove it, then I'm going to find you not guilty. If they prove it, then you're going to get found guilty. You understand? So if y'all want to do a bench trial with me, I'm more than open to, if the state is in agreement, because they're entitled to a jury trial as well. If y'all want to do a bench trial, then I'll hear the evidence.
Judge, since they've suggested they would not oppose it, can I explain to him in more detail
Yes,
pros and cons? And he has some specific discovery questions for me that I'll answer.
yes.
But I shouldn't take more than 2 minutes. Judge.
All right, thank you.
You don't file.
Yes. Sure. Oh, do you need it?
No, I just want to make sure you got the judgment, that you're all set.
All right, and let me put this. So Norma Cox is being recalled for tomorrow. And let me put this in the system. And Norma, if you can check with the jail to see if they're having that person zoom in.
And I text Louise to log in as well.
All right, thank you.
I will be out this Friday, Judge. I will go this weekend with Army.
All righty.
Judge, they said he's on.
No, he's not. You know what? Did you give him the new Zoom link?
So Zoom ID is right here. 891. With the four first digits.
Let me see. Because he's not on. Just 1 second.
I'll come back to
Yes.
those files, Judge. Okay?
Ending in 83. Yeah, he's not on the Zoom.
He's not on Zoom. I'm gonna go check. I'll look at the link.
Judge, you like to go through the files?
Yes. And let me hand this to you just 1 moment. Hmm? Okay, let me just, the defense is confirmed with their client briefly.
Thank you, Judge. Have a good day.
Thank you, you too.
Bye. Thanks. Take care.
Patio.
It's a dead squirrel.
Oh my gosh.
My huskies must have got it.
Oh. There's that.
Judge,
You're welcome.
here's the box.
Okay, and then Eduardo Reyes. Norma, what date do you want to give that? The attorney is filing the competency motion. All right, what date?
I can do February 13th.
All right.
We don't. These will
And Norma, make sure the competency is expedited. All right, thank you.
The second one, is that correct?
Yes. And then Edward Aguilar, that's coming back tomorrow, correct? I believe it is.
No.
All right,
No, on the 12th, you said the 12th, which is the Thursday.
okay.
Regular and the other coming back on Thursday.
Okay.
We needed it.
And that's Norma, that's for discovery. Aguilar,
Correct.
Villanueva is for motions. No, Clinton, he didn't show up, so I'm gonna take care of that today, because this is the second time he hasn't shown. And Nora, if you can make sure his attorney arrives. All right, Espinoza is here. Who's the attorney?
My name's Christian. Can I send her a text message with the Zoom link as well?
Okay.
No, for long. Yes, I sent it by text. Okay, thank you. Bye-bye. She's gonna be logging in.
All right. All right, I need the file on that. I don't have the file. All right, could somebody grab Ray and see what they've decided? And I need the file on Eduardo Espinosa. Yes, so is he requesting a jury trial?
No, Judge, I think we're inclined to waive the jury. I just wanted, and we've had this conversation with state court right now, confirm that in fact the discovery we had is all there is, and there's not gonna be anything else. We can pin that down. We can let ourselves.
All right, and so then this is what we'll do. I'll need you to fill out the waiver of the jury. And then, let me see.
I don't recall whether we submitted a discovery document last time or not.
I will check and see. All right, then what we'll do is everyone on Wednesday, state you need to have your witnesses here. That way we can just do it the entire day. So we'll do your trial on Wednesday, 11th. You'll need to be here at 9 a.m. All right, and then state will have their witnesses, and way that the trial will work. Of course, I'll hear state opening statements if anybody wishes to give opening statements, and I'm assuming both of you already explained the process to him.
We haven't gotten quite that.
All right, so if you all explain that to him, and then we'll go for there, but do not leave until you make sure that you have all of the discovery. All right, is there anything else? Okay. All right. Then just fill out the information and we'll go from there. All right, Miss Christian, if you'll give me 5 minutes, I need to speak to a jury in the hallway very quickly.
Of course, Judge.
Do you need to speak to your client in a breakout room?
That would be great.
All right, so Mr. Espinoza, I'm going to send you to a breakout room with your attorney. When I send you there,
Yes,
do
ma'am.
not leave. You're not excused until I excuse you, okay?
Yes, ma'am.
All right, thank you. Melissa, you should be going to breakout room number 2.
Okay.
All right, thank you.
More.
Do you see it or no?
I got it.
All right, thank you.
Hey, babe. Come here.
That saves me a lot of money on room and board,
Melissa,
you know?
Don't do St. Mary's if you can help it.
I'm here.
hi, okay, we've lost your call.
He should be in the breakout room, Judge.
All right, let me close the rooms. It'll force him to come into this one.
Okay, okay.
Here are not. All right, on this one, let me go into Odyssey and see what's happening. This is a collision, Jason, involving an accident. I don't know if it was on the docket.
I'm sorry, Judge.
This one, I don't know if it was on the docket.
Is it?
And Melissa, he only has the collision involving injury, correct? Or causing injury?
Oh, is this?
This is
Ronaldo?
this is Espinosa, Judge. This is a capital.
Ah,
That one, Judge.
oh, this is the wrong one. Just 1 second. Ah, okay, I have it now. Thank
Okay.
you. Oh, yes. So I have the plea deadline date is December 16th. I guess you moved it maybe?
I had it December 16th, correct, but when I mentioned to you that we may need a motion for continuance, you said go ahead and file it, and so that we could, if we didn't need to bring him over on the 16th, then we wouldn't.
Okay, all right. So, so you want the plea deadline date extended, is that correct?
That would be preferable, yes.
So my understanding is because your doctor hasn't had a chance to do their evaluations or review things?
That's correct.
All right, so state, are you going to have any objections?
No objection, Your Honor.
All right, so did they give you a timeline, Ms. Christian?
So he did send me an email, Judge, and he thought that he could see him in probably early January. So if we could get something either late January or early February, that would be optimal.
All right, and Mr. Espinoza, how old are you?
19, ma'am.
All right. Norma, put this February 18th. And that will be your plea deadline date.
That's great.
Is everyone in agreement to February 18th as plea deadline?
That's good for the state, Judge.
That's good for us, Judge. Thank you.
All right, we'll see you February 18th. And Ms. Ferguson, if you'll make sure he's taken off the docket for December 16th. Do you have any questions, Mr. Espinoza?
No, ma'am. But I would like to talk to my attorney after this, if that's
All right,
possible.
what I'll do
Okay.
is I will send you to the breakout room. And Melissa, once you're done speaking with him in the breakout room,
Yes, ma'am.
we'll just let the deputy know he can be excused from that room.
Of course, I will do so.
All right, thank you. Have a good one.
Thank you, Judge.
If we reach an agreement, would we do the plea deal?
Yes.
Yes, okay.
You, sir. Yeah. It's the. Thank you, Judge.
Yes, and to, all right, so we'll wait and do it today, okay?
If we can, yes.
Yes, all right. Oh, Rashawn and Norman, can I see y'all in the back for a moment, please?
But just so you're aware of it. Technically, it's still
But
lingering.
it's going to be dismissed. Okay.
Yes.
All right.
Raise your hand for me. State your name. John Paul. Are you the defendant in this case? Yes, sir. Are you familiar with the exhibits and stipulations attached here too? Solemnly swear they're true and correct to the best of your knowledge. Are you familiar with this jury waiver, sir? Yes, sir. Can you explain to your constitutional rights? Yes, sir. You understand them? Yes, sir. Consider desire into this plea bargain today, waive the right to a jury trial? Yes, sir. Put your signature right there? Yes, sir. Thank you.
Is like we want her to ask the question, because sometimes people will answer. And she was writing everything down and it kind of. Just let her ask the question, give it a beat, and then answer.
All right. Court is calling 2024 CR 6530, State of Texas versus John Paul Pena. Can I have parties announced for the record? State. Defense.
On behalf, Victoria Cruz, on behalf of Raymond Martinez for the defense.
Are you Mr. Pena?
Yes, ma'am.
All right. Do you have any objection to this attorney, Ms. Cruz, standing in for Mr. Martinez? All right. The court will note for the record that the state is in compliance with discovery, and the court is in possession of a discovery and acknowledgement signed on July 30th, 2024. Did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney?
Yes,
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You understand you're charged with theft, 2,500 to 30,000 as a state jail felony. Range of punishment is anywhere from anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Pena, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's a $2,000 fine. I'm assuming these parentheses mean probated.
Yes, Your Honor.
A $2,000 fine probated. This run concurrent with 713885. State is taking in consideration 715936, 715937, 733879, and 2024 AL 000833. And there's to be restitution of $2,663.70. Who is that restitution to? All right. Any objection to the court writing in that that's to be payable to Home Depot?
No objection from defense.
State, Your Honor.
And will you be able to pay that amount?
Yes, ma'am.
All right. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years and there be no contact with Home Depot and HEB. Did you understand that those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
State, any evidence?
No objection from defense?
All right, state, you may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, please, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client is involved in several community outreach programs. He is the provider to his family, and he has been on GPS pretrial with no violations. I do think that he is going to be a very good probationer. You know, I do this every day, and I do feel that he has the resources and the willpower to do this right.
All right, so why are you stealing?
To be honest with you, Honor, it was, went through a dark hole for foreclosing on a house.
Mhm.
So I own the property and I foreclosed on my house while I was incarcerated.
Mhm.
So to be honest, that's just kind of, the economy kind of went down, to be honest with you. I mean, I have no prior to doing this, you know. It was just something that I did out of spite, thinking I could try to save our family from it.
All right, so you know committing a crime is never the answer. Because then now you have a felony conviction for a theft case.
Yes, ma'am.
And these theft cases are crimes of moral turpitude. And I'm sure your attorney has explained to you that when you have these type of cases, it will impact your ability to obtain employment that requires a license or anything that requires a license. So how many children do you have?
I got 4.
And what are their ages?
I got a 18-year-old, I got a 16-year-old, I got a 12-year-old, a 9-year-old.
All right, and do they all live with you?
I got 2 of them that do reside with me. Or I reside with them.
Okay. Any drug issues with you?
No, ma'am.
And are you employed?
I'm actually a subcontractor.
What do you do?
I do remodeling. Interior and exterior. I do have a DBA that's registered with the state. I haven't filed for LLC yet.
All right, this is what the court is going to do. Going to sentence you to 2 years in the state jail facility, suspended and probated for 4 years, a $2,000 fine that will be probated. This will run concurrent with 713-885. Take in consideration 715-936, 715-937, 733-879, 2024 AL 000833. There's to be restitution of $2,663.70 payable to Home Depot. Why is there no contact with the HEB?
Your Honor, I believe the HEB is a complainant on the misdemeanor case that the state is requesting that we plead to.
All right, and is that a theft case as well?
I believe so.
And what is he alleged to have taken from HEB?
I'm not gonna misspeak to the court, Your Honor. I don't know.
All right, what are you alleged to have taken from HEB?
Food items.
Okay. All right.
Your Honor,
Yes,
apologize for interrupting. May I present those dismissals and rejections?
yes. There's going to be proof of employment within 30 days. No employment as a home health care provider or with minors. So if there's no contact at HEB, then he'll have to do grocery shopping elsewhere. And when we say no contact with HEB, is that going inside the store? Is he able to order online and pick up at curbside or what? What do we mean by no contact with HEB?
No physically going inside the store.
All right, so you can call HEB on the phone and do curbside pickup, but you're not allowed to enter any HEBs. You understand?
Amen.
Okay. All right, there should be regular reporting. By Zoom or in person. Regular random UAs. 100 hours of community service restitution. I'm sorry, that's 200 hours of community service restitution. 100 hours will be waived once he completes parenting classes. The remaining 100 hours will be waived once he receives his full license for your business. Field visits, 1 time per month for 3 months. Probation, is there anything else?
So Judge, just to clarify, I have not allowed to enter any HB and no contact with Home Depot. Did you make that one a condition?
Yes, no contact with, I'm sorry, there's to be no contact with Home Depot. So with that one, you cannot do curbside pickup with that one.
Yes, ma'am.
All right, is there anything else you need from the court to be successful?
No, Your Honor.
All right. Did you review the document? If I can find it. I am looking for the trial court certification. Counsel, do you know if you?
You had it, Judge.
Oh, thank you. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes,
Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record in this court. In order to be successful in probation, communication is key. If you have an issue, let probation know. If you feel as though they're not addressing it, you can always come back to the court.
Your Honor, he is on GPS. How would Your Honor like to proceed on that?
State, do you have any objection to removal of GPS?
No, Your Honor.
All right, and the court will order removal of GPS.
Thank you, Your Honor.
You're welcome. Hello, how's it going? All right, so if you will, with that one, if you'll turn that into them, I think.
It's a county court case. It's gonna be
No, that one's night mag rejection.
second thing.
Okay. Should I take the bottom or does it still need to be signed? No, it's good.
You're welcome.
May we be excused, Your Honor?
Yes, you may be excused. Probation will go over conditions with you.
Thank you.
All right, thank
Your
you.
Honor.
Yes, ma'am.
I'll give this to you once I've completed it and put it in the system.
Yes, Judge.
All right, we'll be back tomorrow. Yes, yes.
Quick motion for you.
Okay.
Everybody, appreciate it.
Ah. There you are.
Thank you so much.
You're welcome.